Hey, so I'm going to try to answer your questions verbally because there's a lot of them. They're all really good though, and you have a really good reason to ask them because you have to make a decision within a very short period of time, and it can make a big difference, right? So, with regard to the question regarding the main claim, we can appeal the denial, and I think that at this point it would go to a judge. Yes, because it's on recon where it was awarded on a date that you could win SSI but not SSD due to your remote DLI. And because it was on recon, the next stage is ALJ. You said I have to go through the medical portion all over again. And I'm not sure what you mean by that. You've already got a lot of it in there. We would still always be treating it like anything could happen. Really, what we want to do is, and we're in the process of doing this, by the way, is going through and trying to find out exactly what you had before the DLI that could help you determine what might have been missing from before the DLI. Maybe you forgot to tell the SSA something or us, and there might be more evidence to add so that when it goes to a judge, he might be able to say, or she, yeah, that is new evidence that relates to that period. And I think it could very well, it does mean that she was disabled provably before whatever date. So this is still the same application. I think when you're saying the last one took almost a year, I think you're saying your recon. I think that's what you're saying, took almost a year. I know we've only been in it for, I don't know, what were we even in it for, 5 months? And then we got the award, but I don't recall what date you applied for that. So we're still in the same claim. The difference when we go to an ALJ is that you're no longer relying on the SSA to order the records. That means that they don't pay for them either, but we have a pretty decent system where it keeps the price down pretty low. And sometimes we don't even forward the bill onto you. So it's just basically, the way I'm seeing is confirming and hoping that there's some missing records from before your DLI. And of course, continuing to bring in all current medical evidence to the judge, so into the file while we wait for the judge's hearing, so that there will be no doubt that you're still disabled. You follow? That would be part of that appealing the SSD denial. And yeah, so, and then your concern of, well, we'll go into them saying, let me just do all your questions and make sure we get these down pat. You said I could completely lose the disabled designation altogether if I appeal again, even if I'm only appealing the disabled date. Yeah, unfortunately, technically, they can flip that. However, they'd have to find that the evidence shows that at age 55, you could do your old job, or you're able to do medium level work, or the job you had, you could transfer that to the job you've had in the last 5 years prior to your DLI. So that whole window there. If you had SGA work that was past relevant work, that you could transfer those skills to another job. That's a pretty steep, it's unlikely. All right. I never want to say never, but it's unlikely. If you are under 55, I would say tread more carefully. But over 55, the risk becomes even less. So while it's a technical risk, I don't know that it's a very high one. So I'll tell you what I would propose, but I want to get to your questions so that none of them are left out. I said disabled in 2018, said disabled in November 24, and to qualify, it would have had to have been before November 22. I don't have your DLI in front of me, but I'm going to assume that that's your DLI. Well, it's never November 2022. It's always at the end of a quarter, so I'll have to double check what your DLI is. A DLI is never in the middle of a quarter. So it's at end of a quarter. So could have been December. I mean, I could look it up. Hold on. You know what I'll do? When I'm done with this, I will strip out all the pauses. So while I'm scrolling, you don't have to suffer through it when you're watching this. Let me just see how I can get to that without losing this. Of course, they're going to make it hard for me to get over there. Open up a new file. A new access. Okay. Is it even in here? It might not even be in here. Just seeing if the DLI was ever put in this section. Of course not. All right. We'll go past it. I'm going to assume it's the end of 2022, but it's something we definitely have to confirm. Okay. Next paragraph about the disabled spouse part. They should have added that to the claim during the first phone call. I kind of think so. Yes. I don't have any of the rules about that in front of me. It's just something I would argue, and then they'd have to say, oh no, according to this rule. And so they told me on both calls that I had to wait to see if I was found disabled as a result of the current claim before they would do anything with the disabled spouse part. Well, the funny thing is, it's a claim for, I mean, let's say you had no SSI application, you had no SSD application, you were going in, and let's say, I'm just giving you an example of when it would just be a widow's disabled, 50 to 60-year-old claim. You don't ever work. Let's say you were a stay-at-home mom for a million years and you never worked. You don't have your own SSD claim to file ever. And if you're not poor, let's say you had life insurance of $500,000 and you're not poor, you could still do a widow's SSD survivor benefit. So that's why I think logically they have to be wrong. Again, it wouldn't be worth my time spending 3 hours researching it. We'll just go with it. You know what I mean? And for that reason, I think you should be, back to March of 2025 in terms of she applied for. We would make that argument, particularly if you have proof of it. You applied and you said you were a widow. So I kind of feel like they were on notice. What else? I'm not clear. I do not know, because normally we don't do, this is not a typical situation. Is there a 5-month waiting period for disabled widows? I don't know. We'll find out. Okay, so they told you on both calls that you had to wait to see if you were found disabled as a result of the current claim before they could do anything with the disabled spouse part. Well, I agree they can't give it to you until you prove you're disabled, but you have. So it should be retrospective. I think you and I agree on that, right? Sent them a letter about this, but I don't know what it said and don't know if they have. No, they don't reply. I sent a letter just to paper trail it. They never replied, ever, ever. On anything, whether it's this or something else. That's not what they do. A lot of times we write letters to protect the client's interest. I just recently uploaded the emails and letter verifying the dates of the 2 calls I had with them about it. Shouldn't they backdate? We hope they do. That's the goal. No, and like I said, they don't respond to letters now. I didn't expect them to. That's not what they do. They sometimes might act on it, but they're never going to give you the courtesy or me the courtesy of saying, oh, I got your letter and you're so right and blah, blah. Never happened in 21 years. Okay, and I don't expect it to happen now. Qualifying with my record with the current claim would result in more funds than qualifying as a disabled spouse. That's the numbers that you showed me, and I thought it was a pretty significant difference. Yeah. So I get the temptation, and I'm going to intervene this in here now. We'd be appealing for an ALJ hearing on it means he can look at the whole case. And like I said, technically he could say, oh no, she could do heavy lifting of 20 to 50 pounds, all day long on her feet. Okay. Technically, but it's just, I would find it to be unusual, particularly if you're still robustly going to your doctor, right? Appealing for an ALJ hearing, by the time the hearing comes around, you could always withdraw that appeal at any time. It's never an ALJ decision until after your hearing and the 2 months after he makes the decision. So in theory, you can even withdraw the appeal probably anytime prior to his decision, even if there's been a hearing. I'm thinking, but certainly before the hearing. And that's, I'm going to say easily 6 months away if we were to appeal today. It doesn't seem like they're happening tomorrow. So that buys you time too. We just get the appeal in. That's not that arduous of a process. I don't know if I gave you the appeal data packet, since we weren't sure what we were doing. But if I did, fill it out. If I didn't, I can get it up to you. All you have to do is put your most updated stuff since recon, the visits, those doctor pages. If you don't want to do that, I could go ahead and just assume that the ones you were seeing on recon are the ones you're still seeing. I will toss them in there. We have to develop the whole file anyway. It's not like we put them in there because we have to rely on the SSA to get them, and we want to make sure they have every damn thing, every piece of crumb of doctor office. We'll be doing that anyway, so that kind of gives you a little bit more time there too. I'm going to read that part again. Qualifying with my record with the current claim would result in more funds than qualifying as a disabled spouse on my husband's record, but it might be worth it to me to go with the disabled spouse. Oh, I see what you're saying. And just take the smaller amount because I qualify for now based on the November 2024 date they expected. I believe you should be getting that anyway while we continued. You should be getting disabled spouse benefit now, regardless of what we do. It will continue. And then we're still fighting this other onset date. You see what I'm saying? So this wouldn't be where you have to not get paid now because you decided to appeal. No, you would still get the widow's benefits now. And while this other issue is being pursued separately. Ooh, that's my kid's high school, and I'm best guessing he doesn't have school tomorrow. That's what I'm thinking. Because we're technically in a blizzard. Sorry, I'm just trying to turn that off. It might be worth it for me to go with a disabled spouse and just take the smaller amount because I qualify now based on that. Yeah, but you can't get the disabled spouse amount until after the date your spouse died, which I think was well after the November 2024 date. So the November 2024 date would be your SSI date, right? You get SSI, that much smaller amount for that period. And then whatever they say and whatever happens with the disabled spouse benefit, you start collecting that. The SSI is going to go away. You're not going to be able to keep both. And then hopefully that will switch to full-blown SSD on your own record since it was better for you than your husband's record. Next paragraph. Points in favor of doing so. You said I could lose the disabled designation if I appeal again, and it could possibly take another year. I already have to rely on my kids for funds. food mostly, and I don't want to have to keep doing that. You're not going to have to because you're going to be getting the widow benefits based on the proven disability, I believe. I don't believe they're going to say, well, that was SSI, which is a different program than SSD. It's not Social Security because the ruling is supposed to be the same on the disability funding. So you should be getting paid anyway, is the way I'm seeing it. Plus, if they date the disabled spouse part back to when they first should have entered that info in March, there would be back pay, I think. So you guys could get paid. Well, no, we're not going to. I don't think we're going to get paid on the widow stuff. Well, I suppose if they retroactive it, and because we were doing the disabled finding that applied to it, yes, maybe they would. So I take that back. One can hope. I'm just kidding. I know you're not hoping, probably. It's not nearly as much as would be on the original claim. No, your original claim. Oh, you mean for your own SSD claim? No, because you're going to have SSI and then widows, right? But I'd like to fight for that if possible, since they're the ones that messed up. Well, they didn't really mess up, except if you're talking about them not putting in for a widow benefit until you I think there's just a terminology difference is probably what's happened. And I'm trying to think when we have basically a dual SSD on one's own record and a widow survivor benefit on the spouse's record. The question is the person medically disabled under the rules? That finding applies to both. Now, when we do, for instance, an SSD and an SSI concurrent claim like you had, T16 and T2 sit up in the little docket there in the e-file that says what kind of claims are being filed. It might be that they have it registered as, okay, now that she's prevailed, the widows can kick in because she got the SSD finding overall. They just may not be talking in a lingo that makes sense to you. And they're not very clear, of course. I mean, they're just kind of clerks there. I don't know if you told me exactly what they said. Did they say your widows is kicking in now when you spoke to them, when you got the amounts and everything? Okay. I'd like to fight for that. Yes, absolutely. You always try to, if there's a legitimate argument for March, for sure. And I think there is. I'm just not giving you predictions on whether right makes mights. But I don't see why not. So we'll see what happens. I assume you applied for the widows now. You called them and said, hey, I've been found disabled under SSI, but I have eligibility as a widow under my husband's record. And I spoke to you about it in March, blah, blah, blah. So let's do that. Based on all the components, what would you suggest we do? Everything you've been saying. The widow's benefits, for sure. That's an immediate, huge benefit to you over the SSI. Fight for the fact that you actually sought to apply in March and they said, oh, I gotta wait till the end before anything can happen. I'm hoping they were just saying, oh, you gotta wait till the end before we know if you're disabled and you can get it, which is true when you file for SSD anyway. So, that's what made it confusing. I would just like to think that internally it's registered, that the person, if we decide it's better to appeal, how much longer do we have to do it? Not much longer, like a week. And what would you need from me? That would be the appeal data form, ideally, but it's not going to be that difficult to do it, even if you can't get that to me. But let me know right away. I'll wait for it if you're going to do it. Otherwise, I will kick it out faster. Okay. And like I said, at the ALJ level, we do everything. We don't have to wait for the SSA. We don't have to respect their ordering stuff, so don't double order, all that kind of stuff. Let's see if we don't. About the question you asked about the spouse benefit, they told me I don't qualify for it since I wasn't living with him at the time of his death. That's bullshit. I don't believe. Were you guys separated? It shouldn't matter where he lives. You were legally married to him, right? I don't think that should matter. So you're telling me that they're telling you you're not even eligible for widow benefits because you guys were separated? That's BS. I believe that's BS. Haven't researched it. Because people who are separated for 9 years, but they never technically get divorced, and they hit the 10-year mark, and then they get divorced, they both get the benefit if it turns out that they are going to need eligibility under each other's things, even if they had a crappy marriage for 10 years and didn't live together. So I don't recall you telling me that they told you that. Is that in that recent conversation? Or did they tell you that back in March? I don't think that's true. I don't think that's true. Okay, other random questions. I'm still going through the records in the earlier time frame and need a couple more days for that. However, I did find pictures starting in 2018. Pictures. So far, I may have more and older to show my mouth. No. Pictures don't help us. Not help us at all. I don't want to see pictures. Believe me, I've had male parts sent to me in pictures. They're not medical evidence. They're not admissible medical evidence because, listen, there's Photoshop. No one's going to trust a picture. They don't have to. It's got to be in your medical records. Your doctor talks about what he sees, and that's how he describes it. So the pictures, don't even spend your energy on it. Pardon me, I think I'm getting lower in your nose. It's not a big thing by itself, but it does show how bad the symptoms are. Doesn't matter. Those are not medically acceptable things. Ironically, if you had sent them to your doctor and they showed up in your doctor's records, they could be. Just saying. So it might help in showing that the severity was bad. No, nope. And the symptoms of everything were bad. Nope. Pictures out of your phone, your personal pictures do not matter. There is such a thing as Photoshop. It could be somebody else's leg. Don't even spend your efforts on it. In the meantime, is there anything I can get in writing from them? Who's them? Maybe the info you received from them. I didn't get any info received from them. Who's them? That they did verify I'm disabled as of November 20th. I don't even know. Did we even get mail yet? I'll have to look at the file. I need it to get EBT because of the new rules. Will you be getting EBT with your new widow benefits? And I'm confused. Go back up and you tell me, did they tell you you can't get widow benefits because you guys were not living together? The funny thing is, if you are legally married, you have the rights and responsibilities to each other, the obligations. He could have sued you for spousal support. You could have sued him for spousal support. I mean, that's until you're divorced, that's the way it is, right? So I don't think that's correct. Are you able to send them new information like a bank? I don't touch your bank account. I don't even accept the information. As you might recall, when we started, you saw none of that on there. I don't take that. You go online and you change your own bank account information. I don't want anybody's bank account information. When you get hacked one day, because people do, I don't want anyone to be able to say, well, you had their information. No, I didn't, because we don't take it. Sorry. When I applied, I didn't have one, but now I do. You call them right now and you give it to them because they're going to have to, if it was SSI alone, you want it to be on direct deposit, you had to hop on there. Didn't you get mail from them? And didn't it say anything? I'll have to see what's going on. All right. So I hope that answers some of those questions. Let's get, like I said, you can appeal. It's not like when you're doing an ALJ appeal, you got all this time when you know that the judge is not making a negative decision. He cannot make a negative decision before he has a hearing. So you have all this time to work up the case, not work up the case, withdraw the appeal and request for hearing. If you decide, no, I just want to sit back. This is different from if you were on asking for a recon after an initial denial, because on recon, they can smack it down at any time. There's no set schedule. This is where it gets difficult. We're supposed to let them get those medical records, and then if they don't get it, they're supposed to let people know that, or they're going to try again, supposed to try twice. Sometimes they screw that up and they go ahead and they deny without trying twice. And you're like, but wait a minute, we could have gotten it to you potentially if the medical provider would have listened to us, even though they didn't listen to you, and gotten it in there, but you didn't tell us you were not going to issue a second request. And they're actually legally supposed to do a second request. So anyway, you're in a much slower position. But my bigger concern is what you told me about, something about not getting your widow's benefits. So we need to find out about that. If it's SSI to start with until those widow benefits get all worked out, so be it. But, get you in pay status of some kind. All right. I hope that answered your questions. We will be talking soon. Yeah. I'm going to double check right now and see if you have the appeal data form. I'm going to shoot it up to you. If you think you can get it back in the next couple of days, so be it. That would be great. If not, I can still file the appeal without it. All right. I like to have it though. That way I don't have to wait for you to get it to me 2 weeks from after, because we want to roll on it. We want it to be there. So when we have staff hours, we can start, hey, we're going to schedule some hours here and things to do, but we can't do any of that until we have it in, obviously. All right. All right. That's Tasha. Can you see Tasha? Anyway. All right. It's Sunday and it's getting dark and the snow is starting. So anyway, big storm here. I'll talk to you later, Renee. All right. I'm turning it off. I can figure out how to turn it off.